Hello. Mr. Edogun.
Yes, my lord. Yes, my lord.
Can you hear me now?
I can hear you, my lord. I can hear you, my lord.
All right. What about Mr. Attila?
I can hear you, my lord, even though the audio is poor, but we can manage, my lord.
Okay.
We can manage, my lord. We can manage.
Are you not in a moving vehicle?
No, I'm in a parked vehicle, parked. I'm parked in NIC Lagos Division premises. My lord.
It's like my lord's video.
Mr. Attila, that one will affect your.
I'm in the court premises, stationed. I'm not in transit. My colleague. Hello?
I can hear you, Mr. Atilola.
I'm seated in my car, but I'm not in transit. I'm seated in the court premises. NIC Lagos. So I think the challenge is from my lord's audio, because we can hear each other, isn't it?
Yes, I hear Mr. Atilola very loud and clear without any interruption.
Yeah. So I'm not in a moving vehicle. I'm not. Mr. Michael, can you hear me?
Yeah.
Hello?
Yes, I can hear you very clearly. I can hear you very clearly, sir.
Yes, it is okay, but I think it's just they can hear me and I can hear them. And I can hear them. Mr. Atilola, you are for the applicant.
Yes, my lord.
And Prince Ademola Idigbe is for the
I'm for the judgment creditor respondent.
My lord, Michael Obasikene is with me, sir. Michael Obasikene is with me, sir.
Oyedekun, you are for the judgment creditor
respondent, my lord.
Respondent. All right. Yes, my Basikene appears to be in chambers somewhere. But I have your names now. So, Mr. Atilola, let me hear you, please.
Thank you, my lord. My lord, this application is seeking the interpretation of the judgment of my lord delivered in this suit on 13th day of July 2018. My lord delivered that judgment. Now, there is a dispute between the parties.
Yes.
Relating to relief 8. Relief 8 of the judgment creditor.
Yes.
And that is why we are before your lordship.
Yes.
The president of the court had assigned this matter earlier to Justice Anuwe, but Justice Anuwe declined jurisdiction that it is
I'm,
better that my Lord who delivered the
yes.
judgment. Yeah. So, my Lord, the application is dated the 3rd day of July 2020. Is dated 3rd day of July 2020. Same is supported.
It's filed on the 7th of July.
Yes, my noble Lord, filed on 7th of July. Same is supported by an affidavit.
But why did it take so long now? It was just late last year that I was told about it.
So, my
Anyway,
Lord,
but let us not go into. Let us make progress.
thank you, my Lord. So the affidavit is sworn to on the 7th day of July 2020. It has 4 exhibits. Exhibit A1, yes. A2, A3, and A4. Same is supported with a written address dated 3rd July 2020.
Yes.
The respondent did not file a counter affidavit. Hence, all my averments in the supporting affidavit are deemed correct and admitted.
No, is it not counter affidavit? Supporting affidavit now.
It did not file any supporting affidavit. No affidavit whatsoever. So all my averments, my Lord.
No. Yeah. The respondent did not file a counter affidavit in the affidavit support the motion.
My noble Lord.
Yes.
The issue here
Go on.
is the issue canvassed, my Lord, is very simple and direct. The claimant sought a relief 8 in his complaint, wherein he asked for 26% interest pre-judgment, 26% pre-judgment interest taking effect from 11th April 2011. That was his prayer before the court. He asked that the interest should be given a retroactive effect. It should be backdated to April 2011. That was his prayer. My noble Lord.
That was his prayer in which head of claim?
Relief 8. Relief 8.
Okay.
He asked for 26%.
Thank you.
Pre-judgment interest backdated to April 2011. My Lord, in his judgment at page 33, granted
yes,
the relief on 21% basis. My Lord did not grant the retroactive effect prayer. My Lord did not grant the retroactive effect prayer. My Lord refused that. So my Lord simply held, interest is hereby granted on the seventh head at 21%. Interest. So, and we paid the judgment sum, the total judgment sum. Now, after the money, the execution, that he must get what he asked for, whether or not my Lord granted it. My noble Lord, the decision of your Lordship is in accordance with Order 7, Rule 5. The decision of your Lordship is in accordance with Order 47, Rule 5 of the rules of this court. Which expressly provides that judgment shall not take retroactive effect unless the court specifically orders so. So that rule provides that judgment shall take effect on the day the judgment is granted, is delivered. My Lord, what is more? In that same judgment, my Lord granted a relief also in our own favor, in favor of the judgment debtor, who is the applicant here. That money is here to be paid by the judgment creditor. Instead, the judgment creditor has suddenly become an Oliver Twist, running after us for a relief.
So that was in favor of the judgment debtor. How much was that?
4,461,000.
Yes, I think if I recall correctly, the total sum was around 15 million. 4
Yes,
million
my
was
Lord.
supposed to be deducted.
Yes, my Lord.
By First Bank.
Yes, my Lord.
Million. So was it not deducted and 11 million paid?
In error. In error. We paid
in which
the
case
total money.
I will properly deem that.
My Lord, in error. First Bank paid the money without deduction. And when they realized, they asked for their money. The judgment creditor did not pay it. So it's owing. My Lord is owing. And bad enough, is now threatening execution on a relief which he asked, which my Lord did not grant. My Lord, we hereby adopt this final address in support of our application. And we urge your Lordship to resolve the issue in favor of the applicant.
All right.
My noble Lord, in conclusion, I want to submit
Yes.
that the rules of this court
Go on.
contemplates written address in support of all application. Written address in support of all application. My learned friend did not file any affidavit, and he did not file any written address whatsoever. Consequently, he lacks the locus to canvass any other argument on point of law. The rule says in support of an application that if you intend to object on facts, you file counter affidavit. If you intend to join issues on law, you file written address. My learned friend did not file any. So he cannot stand up to make any argument whatsoever. And I so submit. Thank you, my Lord.
Well, I've heard you, Mr. Atila. Where is the Mr. Where is Prince? I think. Where is Mr. Adedoku? It appears we have lost Mr. Ademola Adedoku.
Wow. My Lord, let me call him.
Lost Mr.
Let me see if I can call him, sir. Let me see if I can quickly call him.
Because he's not even on any of the feeds. He doesn't want to tell us that his battery has run out or what.
Let me try and reach out to him, sir.
Because the hearing is at a close now. The issues are quite narrow and
Absolutely.
it's not something that can be should take. Because I was going to allow him to respond in spite of what your submission,
Okay,
because of the supervening provisions of the Constitution about all the alterem patem. I restrict him to a few. The records must show that I allowed him to speak.
Very well, my Lord.
That supervening provision
very well, my
Constitution.
Lord. My Lord, can I try and reach him? Can I reach him on phone?
Even though he didn't. Go ahead. I mean, I'm not. I think I saw his client. His client just now. His client too popped in and popped out. I saw somebody, Mr. Suleiman.
Yes, Mr. Suleiman is here, sir, my lord.
Where's your lawyer? Mr. Attila?
Well, he actually sent this to me, sir.
I say can speak.
I'll try to reach him too, sir. He tried sent this to me.
Let him just tell us what he has to say in response so we can take a date and bring closure to this matter.
Okay, sir.
He was here with us. I think just about 5 minutes ago. I didn't see him on the live feed again. Mr. Atilola, any progress?
My Lord, I've just called him. My learned friend is busy on another call.
No, it cannot be now. It cannot
That is what
be.
it is.
This is a properly speaking this is a proceeding that is going on. It can't be engaged elsewhere.
He's on
So
another,
what did
my
he
Lord.
say?
He didn't pick my call. The phone is on call waiting.
My Lord, sorry to interject. I was also trying to get him. Maybe that's why there's a mix-up.
So now Mr. Atilola has let his phone rest now. You, the
Let me try
claimant, I can now record you as being present now. I mean, the judgment creditor, respondent.
Yes, sir. My Lord. Let me try and reach him again.
Who is the Infinix 100? Infinix 10.
Hello? Can you hear
Sir.
me?
You are back.
I'm back. I've been trying to log in again, and then it was really tough. Is the court still sitting?
Mr. Adedo.
Yes, the court is still sitting.
Okay.
We are still sitting.
I'm great. I'm grateful for your patience, my Lord.
Yes, Mr. Adedo.
Oh, my Lord.
The Constitution provides for. The Constitution provides for. I'm sure you had the main. You had Mr. Atilola's submissions.
I had my learned friend moving his application.
Yes. So
Yes,
lastly was saying that. Can you hear me?
I have no right of audience.
My Lord, you have right. Thank you. So,
my Lord,
well, excuse me.
That is not correct, my Lord. Under the rule of your court.
I have said there is all the alternate pattern.
As we call places.
So that is one of the bedrock of our jurisprudence as laid out in the Constitution. So I will take you on some talking points that will pass for submissions on the law or what have you, and then we should be able to take a date for ruling thereafter.
As we call places, my Lord.
All right.
Contrary to what my learned friend actually said, my Lord, under Order 16, under Order 17, my Lord, Order 17, Rule 12, under Order 17, Rule 12, a party who did not file a counter affidavit under Order 16, Rule 12, a party who did not file a counter affidavit has a right to address the court on point of law only.
That is what I'm saying.
As the court places.
So you go ahead.
Thank you, my Lord. The point of law I want to raise, my Lord, first and foremost, relates to Order 47.
How many points of law?
My Lord,
to
it's only
raise?
4. It's only 4.
Hope they are not
And it's
very,
going to be
very
brief.
long.
I'm just
I cannot
going to
write
point
it
the law to
long.
my Lord. I'm not arguing deep.
The first is
Order 47, Rule 30, I suppose.
Order 47, Rule 30.
Order 47, Rule 24. Rule 24.
Of the rules of the court.
The rules of this court, my Lord.
Yes.
It's not complied with.
Yes.
And my Lord, affidavit or no affidavit, a judgment of court cannot be altered, save in the cases of clerical error.
That is true.
My Lord, therefore, no amount of affidavit or issue that has arisen between the parties can alter the judgment of this honorable court, my Lord.
So specifically, what part of the judgment?
Yes, my
Is
Lord.
it the whole judgment we are talking about, or a part of the judgment?
The whole judgment, affidavit of party can alter anything. The judgment remains as it is. So
yes,
all the
it remains as it is, but what is the bone of contention arising from the judgment?
My Lord, now, our prayer 8, where we ask for 21%, the judgment is before the court. Where we have for 21%.
Is this the second point of law?
Yes, my Lord, is the point of law. I will end it. Our prayer 8 is not asking for 26. The judgment is clear. Document cannot be altered. We ask for prejudgment.
It's not asking for 26%.
We didn't ask for 26%. It is there, my Lord. 21% prejudgment interest as against the fallacy that we ask for 26%.
Yes.
And my Lord, reading the judgment from beginning to the end, is only prayer 5 that failed. It is only from the analysis of the court, it is only prayer 5 that failed.
All right.
And my Lord, there is no analysis or reasons for the failure of prayer 8.
Yes.
So our submission, my Lord, is that my Lord did not copy it verbatim. That my Lord did not copy it verbatim at the tail of the judgment. That my Lord did not copy it verbatim at the tail of the judgment has not altered our prayer 8 that court granted.
We submit that the court did not copy it verbatim. That is, we did not copy prayer 8 verbatim.
Verbatim at the tail of the judgment.
At the tail of the judgment.
Yes, my Lord.
Tail as in T-A-L-E.
Towards the conclusion of the judgment. T-A-I-L.
Okay. T-A-I-L. T-A-I-L. Okay, at the tail of the judgment. Thank you.
Yes, my Lord. Does not mean that my Lord has not granted prayer 8. Because none of the prayers was copied verbatim while making the order. None of the prayer was copied verbatim while making the order. And then, my Lord, just the one before the last point, my learned friend made reference to Order 7, Rule 5.
I did not.
That is what I had. Maybe you guide me before I move on.
I did not.
47 rule 5. I think he
47.
meant order 47 rule.
As a cop,
Mr.
Yes,
Adedoku.
I mentioned 47.
as a cop places. As a cop places.
47 rule 5.
Yes, my lord. For the 47 rule 5
Yes.
actually deals with ambiguity. And it has given my lord wide range of powers. Wide range of powers.
Yes.
Which include clearing the ambiguity, no. Just a moment, my lord. I'm about to round off. My lord, our point is order 47 rule 22. Orders 47 rule 22.
Yes. 47 rule 22.
Yes, my lord.
Go on.
The court may suo motu on application of any party affect, correct, resign, or vary its order or ruling.
Yes.
And in this case, since no reason has been advanced, why our prayer hate was not when no reason has been advanced for varying or dismissing our prayer hate as prayed. When no reason has been advanced for varying or dismissing our prayer hate which has been granted. Because you exercise its power under order 47 rule 22(1)(b) in favor of the respondent.
Where no reason was advanced for. Hello.
For any variation whatsoever.
Hello.
Hello, my lord.
Okay.
Hello, my lord. I can hear my lord.
Yes, yeah. Since no reason has been advanced.
Yes, my lord. For not granting prayer hate.
Yes.
My lord, is deemed granted.
It's deemed granted as prayed. You are in court. Please stop laughing. You are before the court. This is courtroom. Mr.
Adedoku. Okay.
Yes, my lord.
You see, say it is deemed granted.
Yes, my lord. The prayer hate is granted. And the situation in order 47 rule 22 has arisen for clarification.
The situation in order
22.
47.
Order 47 rule 22.
Rule 22.
Yes, my lord.
22 has arisen.
Has arisen.
Yes.
And it is only subject to the wisdom of the court and the intent of the court, and not any party's affidavit whatsoever.
Thank you. The wisdom and intent of the court.
Of the court, not based on any party's affidavit or legal argument. And that's the reason why, my lord, we have not filed any counter affidavit, because it's of no use. My lord knows what my lord has done.
Thank you.
All we agree is that there is a dispute as to the interpretation of granting prayer hate.
So you are saying in your words the dispute is on the grant of prayer hate.
Of prayer hate, my lord, as prayed.
has prayed. Thank you.
Thank you, my lord.
So, yes.
My Lord,
Is there any
just
other thing?
one reply on point of law. Reply on point of law, just one in 3 minutes. And my reply is that
Okay.
judgment and orders of court are express. They can never be implied. That's number one. And we argued it in 3 minutes. Judgment and orders of court are express and not implied. Number two, a party who is dissatisfied with the ground.
My lord, this is not flowing from it. I argued on point of law without affidavit. I object. Excuse me, I object. My lord, I argued on point of law without affidavit. If my learned friend will have any further reply or point, it should be in direct response. It should be direct response to the point of law I raised. But it's opening a new ground of argument.
I'm not.
You are opening a new ground of argument. You are bringing the issue of appeal, which is not my.
No,
it's none of my.
Mr. Adedoku.
You said you can
come in here.
Yes,
Excuse me, Mr. Adedoku. Mr. Atilola, excuse me, gentlemen.
Sir.
I did hear Mr. Adedoku.
My lord, my name is Oyedokun.
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 Where did I get where Adedoku from?
Ademola Oyedokun.
You should have corrected me since now.
My lord, I never knew that my lord did not
initially.
I'm sorry, my lord. The name was on display. I'm really very sorry.
You know, sometimes Oyedokun, I think it's correctly showing now.
Yes,
Oyedokun. Thank you.
My noble lord.
Yes, gentlemen, I wanted to say, I was going to excuse me, Mr. Atilola. Mr. Oyedokun, in his 4-point submission, in one of them, he had said that the judgment of the court in that prayer 8, it can be implied as having been granted. Mr. Oyedokun, I think I heard you say something like that.
I said it was granted. That it was not copy verbatim from the fact, statement of fact, does not mean it has not been granted.
It's implied. That's what you are saying. It's implied.
So I think in specific response to that, Mr. Atilola is saying is that the judgment and orders of court are expressed and not implied. I think that is the direct. He has not gone outside the bounds.
Absolutely.
As the court places, I abide by the observation of my
because
lord.
if he has done so, it will be apparent even to me.
As the court places, my lord. As court places, I trust the judgment of my lord.
I'm flowing from that, my lord, and I'm about to conclude. Flowing from that, my lord.
Yes.
My learned friend now referred to a particular rules where he say ground for prayer where the court did not pronounce on ground. And I said, a party who is dissatisfied with any part of a judgment, the remedy open to him is not to imply.
Yes.
But to appeal that my lord did not pronounce on issues canvassed.
The remedy open to him is not to imply.
It's not to imply.
Yes.
But to file an appeal that my lord did not pronounce
but to
the issues he canvassed. It's not for him to imply. And finally, my
For
Lord,
these submissions,
sir,
yes.
and finally, my Lord, in the event
Yes.
that my Lord finds merit in our application, then the cost to be awarded has to be punitive. That is my, so I'm asking for cost. Everyone, a claimant made a prayer in a particular form. My Lord granted some and refused other
Lord, this is
parts.
reopening arguments. That is not in relation to your prayer for cost, which I have
I'm
right of
asking for
response.
cost.
Okay. Now, gentlemen, excuse me. I think we can put this one aside about punitive costs because those are purely
And my Lord,
within
he brought me before
areas of
you.
the court
He's the one who filed
discretion.
the application. I didn't force
And
him
I'm
to
not
file it.
even, excuse me, sir. Excuse me, sir. I'm not come to that, but there is a point I want both of you to clarify. This back and forth, I just pray it hasn't just leapt out of my mind or creeped out of my mind. There was something I wanted both of you to say
Address my
something
Lord.
about. Yes, it's just coming in and going out of my mind. I should have just stopped listening. I should have just written it down somewhere. Yes, it has to do with this. Mr. Atilola had said, I'm speaking to you now, Mr. Yedeko. Mr.
Yes, my Lord.
Atilola had said that there was this award or grant that I made for the judgment debt on the sum of about 4+ million, and that the judgment creditor has not paid that money to the.
Okay. Thank you, my Lord. I wasn't there when that was said.
Yes.
My Lord, that order was made with a
I
profile.
know, because when the transmission broke at your end,
Yes.
I knew that I had to bring this up before we
My
round
Lord,
up.
that order was made with a proviso, if I may read. The only further order to make is that a certain sum of 4.4 million be deducted from the claimant's terminal benefit comprised in the 7th head of claim when the claimant is paid, not more than 30 days from the date of judgment. My Lord, they pay more than 6 months afterward. And that is why they themselves did not deduct it from the source, because they knew they had no authority to do so, because they were paying after 30 days. That order was conditional and only based if they paid within 30 days from the date of judgment. They didn't pay within 30 days of the judgment, and when they paid, they themselves, if they were paying within time, they could have withheld it from what they paid. It was not for us to pay, it was for them to deduct it from the source if they pay within 30 days.
And when you are not online, because he said that it was a mistake.
From the judgment of the court, from the judgment of the court, my Lord, if it is paid not more than 30 days from the date of judgment, the judgment was given on 13th July. They didn't pay until sometime very close to.
You know something to do. Something I have observed as a practical reality in this work we have been doing for many years now. When courts give orders, generally we try to give a time period within which that judgment can be complied with, because the immediacy of performing a judgment, the act required in the judgment order, it requires other forms of human activity. Somebody receives the order, the judgment. Somebody gives writes a memo to so and so person, release this money pursuant to this judgment given. It may take a number of days and what have you. They may be brainstorming, but what we know, what gives us encouragement from our part is that judgments are complied with. Nevertheless, even though outside the time, yes.
My Lord, now from the look of things, even that particular order,
the other day
that particular order is against them, my Lord.
General. Yes.
That particular order is against them. the order of the court against them is that their certain sums should be deducted. They are the one who have failed to perform the order of the court. We are not the one compelled to do an act.
It was an error.
And we are not. This is a situation where we are saying the money they paid us is not even sufficient.
Okay. Anyway, gentlemen, I think every man has had his say.
As the publicist,
to the point of reason, or to the point of reasonableness. Is there any other thing to add? I don't think there is.
Well, my lord, there is none. Only that to my lord, the only to add on the issue my lord raised.
I need
your lordship.
I need to respond to the issue of application for cost.
Well, I said that one is not. I'm not contemplating costs now.
As the court places.
Okay, you want to say that
because they brought us before you, my lord. They spotted ambiguity. We saw a very clear decision. They are the one who claim there is an ambiguity. We have a very clear judgment in our favor. So they are the one who saw the ambiguity.
I have rested my case. I have no further submission.
I've rested my case.
I've rested my case.
Our ruling will be delivered. Our ruling, excuse me, gentlemen. Our ruling is going to be delivered virtually also.
As the court places. As the court places.
I think, and that is when we will have known our new president and our new state governors. Wouldn't that be a nice time to give it?
As the court places. As the court places.
I see a free opportunity to campaign, but I won't in this courtroom.
No. I'm not asking for campaign. We are neutral from where we are. We are talking about having governors, knowing who the governors will be. So we will review, some may continue. Everything is in the hands of God and the people.
Yes, as the court places. As the court places.
So, thank you, gentlemen. Let us. Can we say the 30th of March for ruling?
It's fine, my lord. It's judgment.
It's fine, my lord. Fine. It is fine.
Yes. That 30th. Okay, it's all right. Gentlemen, I think you had me on that last word. Cases are adjourned to 30th of March 2023 for ruling.
As the court places.
Thank you, my lord.
Thank you very much.
Thank you, sir. Thank you, sir.
Okay, gentlemen, we can go off air now.
Thank you, sir. Thank you, my lord. Thank you, sir. Thank you, sir. Thank you, sir.
All right. Thank you. All right. Okay. You can. Thank you. So, gentlemen, that is the age we give in.
Okay.